Welcome back to Next Steps for Seniors Conversations on Aging. Our topic today is really about pre planning and avoiding probate. And we are incredibly blessed to have a wealth of knowledge in our studio today, Mallory Calabat from Clark Hill here in Michigan. But if you're listening across the nation, I mean, definitely this is an opportunity to learn a lot about what probate is and what to do through it, and then how to avoid it, which is the key words, right? So Mallory, I'm going to first give your phone number because we did that really quickly at the end of the last segment. 248-530-6342. And you're just handling things in Michigan, or can you go outside of Michigan?
So I typically work only with Michigan clients, although we do have a number of clients out of state that we're able to help. Our firm is nationwide, so chances are we have a probate or estate planning attorney where the client might need it.
Fantastic. So look up Clark Hill. Good old Google. Okay. So moving on, we talked briefly about, do you need a certain amount of money in the last segment in order to have a trust? Do you need a certain amount of money?
I think that's a misconception in terms of the benefits of a trust. It's not, there certainly is benefits to having a trust if you're high net worth, right? There's certain tax and estate planning or estate tax planning that we can do with trust agreements that are, better equipped than using our standard will. But really what a trust is beneficial for, even if you don't have what you consider a high net worth, is control. You want to make sure that you have management in place if you become incapacitated, but even more so for the beneficiaries that you name in the trust. This is particularly helpful for instances where the individual has minor children, possibly as beneficiaries of the trust. You may not want them to receive their inheritance entirely at age 18. With a trust, you could stretch out the provisions in terms of when they get the distributions, whether even if they're not a minor, if you think they just might have spendthrift issues, substance abuse issues, maybe a child with a troubled marriage that you don't want a divorce to sort of deplete their inheritance. There's a number of ways that you can protect against these types of things. And the trust is really a great mechanism to do it because you can really tailor it to your specific needs.
Well, and unfortunately, as crazy as this is, we all know divorce is 50% of marriages, if not higher now. So it's very alarming when, you're leaving money to somebody and then all of a sudden there's one or two divorces going on and you're like, okay, that wasn't a good decision.
So clients like to have, there's certain provisions we can write into the trust that will protect against, if the child is going through a divorce at some point, we can suspend their distribution rights, or we can require that they enter into a prenup. There's all these different mechanisms that we can put in that will try as best as we can to safeguard in those types of situations.
So much to think about. And I'm so grateful for this information. It really is incredible. What can you tell us what documents you think everyone needs for a complete estate? Like, we want to make sure we have all those key documents.
Absolutely. Yeah. So first and foremost, everyone should have a will. Even if you have a trust, you should always have a will for the reasons we explained previously.
The pour over
provision. Exactly. Exactly. There you go. You're taking good notes. But even if you don't have a trust, your will would be what designates where your assets go if something happens to you. So the will is pretty much almost always you will need one. And a trust you should need in most cases, but there's ways to avoid probate without a trust, and we can talk about those after. But in addition to planning for death, a complete estate plan plans for incapacity. Your trust will include provisions that, determine how your trust assets are managed for your benefit if you become incapacitated. But you should also have a power of attorney for finances. And this will allow someone to manage, first and foremost, any assets that are not in your trust, but also handle your simple bill paying, right? Make sure that your house is being maintained. Make sure that you are filing your tax returns. All of those things that your trustee may not be able to necessarily do on your behalf. Your power of attorney, who could be the same individual, would grant that authority to someone to act on your behalf if you're unable to do so on your own. You should also have a healthcare power of attorney. In Michigan, that's referred to as a designation of patient advocate. This just allows someone to make personal and medical decisions for you in the event you're unable to communicate those on your own.
And I want to say one thing about that, because I think this is very important. Please put a lot of thought into who that person is. And here's why. You want that person to do what you want, not what they want.
Right.
And it's really critical because if you've got 3 kids, for example, one of them is always pleasing you and the other 2 are always off on the, you want the one who cares about you the most because you want to make sure, and they won't be offended because at the end of the day, really, I don't know that people are jumping up and down going, pick me, right? It's a huge responsibility and you do not want to take it lightly. But I had a relationship with a family and the person kept doing what they wanted. And I kept saying, you're the power of attorney. And you're like, yeah, it's my decision. No, 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 no. It's your decision to do what they want. We already know he doesn't want to be on a feeding tube. We already know. I mean, he's told me all of this and you. So why are you putting him on a feeding tube? But, these are the questions, though. You really, please, really highly think, pray, and consider who this person is.
Absolutely.
Oh my God.
Absolutely. Yeah. And, to that point, choosing any of these fiduciaries is a very important decision. It's not just a matter of trust or they're your family, so you want to appoint certain people. It has to be the right person for that role, and particularly with the healthcare power of attorney, it's an emotional decision. If it's a decision to, remove,
No, it's life and death.
yeah, and it is. And if it's not someone who, even if they care for you very much, if they're going to be overwhelmed or unable to make the right decision for you, they may not be the best person. So that's often one of the most difficult decisions for clients to make.
So we're going to transfer more into the pre-planning now. So the one thing everybody says, and I got to be honest, after they go through this with their parents, they're like, okay, they look me in the eye and they go, what do I need to do now so this doesn't happen to me?
That's right. That's oftentimes clients will call to do their estate plan for the first times, and it's after a loved one has passed and didn't have any planning, and they realize, I don't want that to happen.
Please do not let me do this to my kids.
Yeah, exactly. And then we will walk them through all the documents that we just discussed and really tailor the plan for them. In some cases, people don't want a trust. They want to just a simple plan. They don't want there to be any strings attached for when people inherit from them. And in that case, you can still avoid probate even without having a trust.
Okay, tell us about
So for those types of clients that maybe don't necessarily want a trust or don't see the benefit of it, we always recommend that they have beneficiary designations on bank accounts so that if anything happens to them, those, the assets of that account will go to whoever they've named. It kind of tricky if someone has to leave before you and you don't update that. But on the first level, that is a very, wise thing to have if you're not going to have any other planning. I talked about earlier ladybird deeds, which are enhanced life estate deeds in Michigan. You can name, if you own real estate, you can name people to inherit that property if you pass away and you still own the property at that time. And that will avoid probate as well, as long as, again, those people survive you. So there's a number of ways that you can implement transfer on death or beneficiary designation provisions on various assets that will avoid the need for a probate estate administration after you pass away.
So we have 2 minutes left in the program, and this is a thing that a question I get all the time. How do you determine if someone cannot sign a document? Unfortunately, Alzheimer's, cognitive decline is on a rise, and 1 out of 3 almost at this point. So how do you determine that?
So it can be difficult, especially as you said, we have an aging population that's living much longer and becoming more susceptible to these types of diseases. And as an attorney, you really are their sort of first sort of gateway to assessing whether they have capacity. If they haven't gotten a medical evaluation yet, you as long as it's a long-term client, you'll notice things. But particularly to sign estate planning documents, particularly a will or trust, the threshold for testamentary capacity, it is somewhat low in that the individual just needs to know who their heirs at law would be, so who their natural family members are that would inherit from them if anything happened to them. They need to know the extent of their assets, so how much they have in these bank accounts.
At least they have a really good idea.
Exactly. And they have to understand the disposition that they're making under the will and trust, naming the beneficiaries and understanding that those individuals will inherit upon their passing. And they have to understand and appreciate that decision. So the threshold for testamentary capacity is somewhat low, but that doesn't always, mean that the person should be signing estate planning documents.
Yeah, I feel like we need to be careful with that.
Mhm.
I've unfortunately have too many stories. You can imagine the stories that I hear here at Next Steps for Seniors with brothers and sisters arguing and then saying, "Oh, you got dad to sign that last minute," and it's families. Let me just say this: the one thing your parents would want is for the brothers and sisters to get along after they're gone. So whatever you can do to keep the peace, I would say far number one. Number two is all the other stuff that goes along with that. Can you share your number one more time? We are so blessed to have you here. And I really do hope that people, if nothing else, go through the process of just making the call, right? And have your consultation.
Absolutely. Yeah. And there's no risk of calling. We're happy to answer any initial questions you might have, without a fee and see if this would be something that you might need to move forward with an engagement for us. But please don't hesitate to call. My direct number is 248-530-6342.
And thank you for tuning in to Next Steps for Seniors, conversations on aging and pre-plan. Awesome. Perfect. Oh my gosh, Cheryl.